so I want to make sure that it's working. Rachel, sitting over there, stand up, Rachel, is our Twitter, what's the word for it? Twitter something or another. Social media director. And she's going to be tweeting, and she's also going to be looking at anything that's coming in from the live streaming audience. So we want to welcome the live streaming audience, such as there is. I'm told that this is the first time in Charleston that such a thing has been tried, so we are experimenting. The other experiment here is the very nature of this pre-conference. Katina and I got together, and she thought there would be good to do a pre-conference on something that actually related to the long arm of the law sessions that we've now had for 3 years at Charleston, but something more substantive, something that tackles certain issues in depth. And so we came up with this idea, but one of the things we'll be looking for from you folks before we end or afterwards are your suggestions for what we might do in future Charleston conferences that would be helpful, topics to tackle, whether you think there should be a whole day event, a separate event somewhere else, some other time, or nothing at all. So this is the other part of this event that's an experiment. Now, the format that we're going to follow is I have a very easy job. I just have to invite people who really know what they're talking about. Then I can sit and listen to them. But we have 3 of those people with us today. We're going to start with Judy Ruttenberg from ARL. She's going to talk about ADA and disabilities as they relate to libraries and contract terms and so on and so forth. Our second speaker was to be Bill Hannay from Schiff Hardin. He's a Charleston stalwart, standby, regular. Bill, unfortunately, went into the hospital for observation last Friday, and they kept him, and they cut him up on Monday. So he's survived the surgery very well, but needless to say, he can't be here. Katina tried to talk him into actually doing this from his hospital bed, but we decided that was probably not going to happen. So Bill was writing papers for us and sending them on Friday, Saturday, and Sunday. Bill's stand-in will be Bruce Strauch. Bruce is starting off another pre-conference, but he should be here by 10, and he would be in our second slot. Kevin Smith on MOOCs would be our third. However, if Bruce doesn't get here, Kevin has kindly, they're all swappable time-wise. So in between each of those, which each section I imagine will take about 55 minutes, you all get to stand up and walk around and stretch, break, get a glass of water, and then we come back. So that's how we're going to do it. Are there any questions? Housekeeping questions or other kinds of questions before we go forward? Well, if any come up, we can deal with them then. So let me introduce Judy from ARL. I'm going to let each of the speakers give you their bona fides if they feel the need to do that, and then launch into the presentation. So thank you very much for coming. Thank you. Somehow you have to attach that.
Okay. I will figure that out. Excuse me. Thank you, Anne, for that. How's that work for everyone, audio-wise? So this is I don't know how big our live streaming audience is. Welcome to you. But if anyone does want to take the opportunity to move up, or not, that's okay too. But I'm going to sit as you're sitting, and we're just going to talk. And I hope that we can have a really interactive session, and I've saved plenty of time for us to have questions and answers. So, as far as my bona fides, my name is Judy Ruttenberg, and I'm a program director at ARL. I'm not a lawyer, as my esteemed colleagues on this program are, but with my colleague Prue Adler, who heads ARL's public policy initiatives, I support ARL's new working group on accessibility and universal design. This working group is the follow-on to a task force report we wrote on services to patrons with print disabilities 1 year ago. So if anyone in this audience is unfamiliar with the term print disabilities, as I was 18 months ago at the start of the project, a print disabled person is someone who cannot effectively read print because of a visual, physical, perceptual, developmental, cognitive, or learning disability. So take a moment to ponder that list and consider that it is a large population. And it's a higher than ever before population on college and university campuses, with students of all ages, a growing number of returning veterans, and a generation of traditional age students who grew up as beneficiaries of inclusive special education and disability legislation in K-12. So ARL's Print Disabilities Task Force issued its final report 1 year ago, as I said, in November. Since then, ARL has formed this more broad task group working group on accessibility and universal design, looking at accessibility more broadly than print. We have undertaken an accessibility review of ARL's own web content, publications, and processes, and are in the process of retooling the production of our own publications and content to meet accessibility standards. We've become a host institution for the National Digital Stewardship Residency Fellowship, which is a program, an IMLS-funded program out of the Library of Congress. And it's in its first year, and we have a resident fellow, Molly Schwartz, working on developing a digital accessibility toolkit. So it is a priority. It's become a big part of what we do at ARL. I'm thrilled to be a part of this pre-conference, to be asked to speak here at Charleston. I think you represent an audience of natural allies in this area and of key decision makers. So thank you to Anne for asking me to be a part of this. My objective today is in the title of my presentation, to claim that digital content accessibility is a civil rights issue, a matter of equity and inclusion in higher education, and that demanding accessible products should be non-negotiable and a deal breaker. You can no more waver, my claim, that on accessibility language or consciously allow it to be watered down than you can agree for your license disputes to be mediated across the globe from where your institution sits. And then, of course, to give you good models and ideas to accomplish this. ARL didn't invent this issue. And there is plenty of good work and being done and good practices to follow, so I want to share that with you. That was the purpose of our task force. It's the purpose of our working group. So to emphasize that nobody has to go this alone, and there are good models. Okay, that's a long first slide. So there are several ways to kind of dive into the accessibility story or tell this story. I can start with personal stories, or sometimes people in this area of usability and accessibility use personas. But the point is to tell stories about or describe what it's like in the digital age to be accepted into a college or university and be unable to access course content, courseware, research materials, basic websites in a timely manner in order to succeed. And so those kind of stories are meant to appeal to your sense of justice under the law, or injustice under the law. I can list the dozen and growing number of complaints and settlements against institutions filed by the Department of Justice and or the Department of Education and or the National Federation of the Blind, and institutions that have entered into costly settlements in order to remedy the complaints. And that list might appeal to your sense of fear. Or I can map the principles of universal design to the core values of librarianship and appeal to your sense of mission. So in the end, I couldn't really decide which was the best opener, so I'm going to try to incorporate kind of all three in my presentation today. But I do think we have to start with the law and what the law and disability policies are. This is the context in which you're operating and trying to do your job. Within that context, accessibility is a shared responsibility. It's certainly not only the library. But we will talk about where libraries fit into that and talk about being a key campus partner in increasing accessibility, both to diminish the very real risk of being out of compliance with the law, but also to fulfill our missions to enhance student learning, to enhance faculty productivity. And then, of course, to talk about the business of licensing and procurement, providing content to your campus and how you can take steps through licensing language and contract language to ensure that content is accessible to the broadest possible audience. So let me pause just here and ask if anyone here is on the provider or vendor side. Okay, great. So also key partners in this, right? So I'm glad that you're here, and I hope that during the Q&A that you'll participate and we'll come to, and we can really have an open discussion about that. That's great. So what you see on this slide are basically the sort of constellation of laws that protect and protect the rights of users with disabilities in higher education. Okay, the three key provisions of the Americans with Disabilities Act, Titles 1, 2, and 3. Not going to go through them chapter and verse, but we'll refer you to ada.gov. And I know that Charleston is also, an international conference, and ARL is a North American association. So in our report that I referred to, we do have information about Canadian, because we also have members who from Canada. The law is different, obviously, in different places, but many countries have disability legislation. Many states within countries have disability legislation. So what I'm focusing on here are law and disability policies in the US, but I think when we talk about standards and licensing, this is a more inclusive kind of conversation, okay? But we have Section 504 of the Rehabilitation Act, prohibiting discrimination on the basis of disability for those who receive federal financial assistance. Oversight for that is the Department of Education. We have Section 508 of the 1998 amendment, which people kind of know as 508 compliance. It's probably in some of your contract language to be 508 compliant. It is the standards that cover and apply to the federal sector U.S. federal sector in the technology that they procure or use, so that those, say, web presence and technology have to be accessible to federal employees and to the public. And it doesn't automatically convey to higher education as written, but the link, or the reason that it does, and the reason that 508 compliance is important in higher education, is because the Department of Education interprets the Assistive Technology Act, also 1998, to mean that states who receive funding under the Assistive Technology Grants Program are subject to the standards articulated in 508. So any guesses how many states receive that funding? All 50, yeah. So, okay, good. So 508 crucially, does not apply to the private sector, right? It's not a 508 violation for Amazon to produce an inaccessible Kindle. It is a 508 violation for a college or university to require the use of an inaccessible Kindle on a college campus in coursework. Okay, so that's a critical distinction, and the reason why I think this becomes such an important issue. Because there is that kind of disconnect between what's being produced and what's being consumed and who's at risk, okay? So this was kind of expressed in a Dear Colleague letter jointly written by the Department of Justice and Department of Education in 2010, and this was a letter to college and university presidents. And really just kind of honing in on the responsibility higher education has for protecting the rights of people with disabilities in education, looking at e-text after e-book, after e-reader pilots on campuses and saying emerging technology is really important, and we call your attention to your responsibilities in this area. So this would also be an opportunity to tell stories about students who receive reformatted textbooks 6 weeks into the semester students and have to drop courses, which has happened. Students who use screen readers with library databases for whom it takes 10, 15, 20 minutes to find the search box with a screen reader, hours to find full text articles, only to find that those full text articles are image PDFs and inaccessible. This is unacceptable as service providers. It's a violation of the law, and it's what we're here today to try to push forward and try to help solve. So here's that growing list of institutions of higher education who have received these complaints. The institutions on this list specifically for inaccessible e-readers. Some are very new and ongoing, like Louisiana Tech, and which you may have read about recently in the Chronicle and Inside Higher Ed, and which, because of the way this has unfolded and having a complaint lodged against it, it's on a now very aggressive timeline to meet accessibility requirements. I think by the end of 2014, and that's it's a big campus. It's a big deal. Some institutions on this list, like Penn State, entered into voluntary settlements with the National Federation of the Blind and have become absolute leaders on this issue, and have leaders that many of us can emulate and learn from, with plans for how a huge campus and with many services can go from having a complaint lodged against it to being a leader. And there, I urge you, and it's in my resources at the end, to look at Penn State's website for this. So how does one do this? Early on in our task force work, when we first put the task force together, Prue Adler and I at ARL met with Eve Hill, an attorney at the Department of Justice in the Civil Rights Division, about the work we were doing. And about this, I mean, really about complaints against institutions and what was her advice. And according to Hill, she stressed the importance, and this is in our task force report as a recommendation, of making a plan, an institutional plan, to get websites, web content, and services in line with accessibility requirements. So, and I think that there's a perception, according to Hill, a false perception, that making such a plan, making it public, making it transparent, represents the kind of risk of admitting that you're not currently there where the law says you need to be. Study after study shows that. Everybody knows that. Everybody knows that that the vast majority of you are in the same boat on that, and not and have inaccessible content all over, and huge websites and legacy content and all of that, and everybody knows that. The risk is in not making a plan. The risk is in not establishing a transparent and accountable timeline to getting there. Okay. So moving on, there is also significant accessibility activity under the Copyright Act. And here's where I'm going to underscore my non-lawyer and maybe point to somebody else on this panel to help if there are questions. But the key provisions here are 107, fair use, and 121, known as the Chafee Amendment, the primary exception regarding accessibility. And I have Authors Guild v. HathiTrust here because the 2012 decision of Judge Baer strongly affirmed that libraries may rely upon fair use and 121 to make works accessible. So we'll talk about that decision in that case. So what is 121? What is the Chafee Amendment? It is an exception to copyright that says copies may be distributed to individuals with print disabilities. This is an exception to making copies, right? But not just by anyone, by an authorized entity. And that authorized entity has to have has this service provision as a primary mission. Okay. So in 2012, and I am aware that this case is currently on appeal, but as of the last published decision that we have, and I'm sure that most of you in this room, if not every last one of you, is familiar with the HathiTrust, and it's a collaborative organization for the long-term preservation of digitized materials. So initially seeded by the book scanned in the Google Book Search project, which made the HathiTrust vulnerable to the same litigation faced by Google for copyright infringement. But in 2012, Judge Harold Baer in Federal District Court found strong support for the HathiTrust with respect to accessibility under copyright law. The court held that contrary to the Authors Guild arguments, libraries are entitled to a full fair use defense and are not required to rely only on sections 108 and 121 to preserve and provide access to library collections. They held that mass digitization for search, preservation, and accessibility is fair use, that two of Hathi's purposes, search and accessibility, are transformative, the use of the works beyond that which they were originally intended. And the court also found that the use of the entire work is fair where appropriate to that purpose. So it was a strong and clear signal and victory in this case for libraries. Judge Baer, in fact, suggested that libraries have provision of collections to print-disabled individuals as a primary mission, making them potentially authorized entities under Chafee. And here's the very, very strong language on fair use and the transformative use of the HathiTrust materials for this. So that's an evolving story, and we'll look forward to more on that. Okay. So that's my very, very quick kind of traverse through the land of law and policy. But there are limits to law and policy, or I wouldn't be working my way up to licensing and procurement practices. If everything was taken care of by legislation, our work would be done. The first two bullets on this slide, I think, are limitations of the law with respect to protecting individuals with disabilities, protecting the rights of individuals. And the way that undue burden, which is of course part of the ADA, it's a way for an organization to claim exemption from accommodations based on making a claim of an undue burden. And that comes into our licenses, I think, in the form of licensor shall make reasonable efforts to meet a certain standard, say 508 or ADA. And I think that's a really big out. And I think we should talk about that and push harder on that. The other is the burden of self-advocacy and self-disclosure. And this basically refers to the transition to higher education that students make when they leave the K-12 environment, where teams of people were assembled to ensure their success in getting them through K-12 to an environment where service by service, professor by professor, book by book, people have to self-disclose, which I think has privacy implications, and which should speak to our missions again, and self-advocate in order to get to the point where they have equal services and equal opportunities in education. So the other is that the law simply lags behind technology. The ADA is from 1990, these amendments in 1998, and you can have a situation where a product or service is technically 508 or ADA compliant, but not usable. And I think this is where, again, a kind of appeal to mission. Many of your libraries, I'm certain, have usability testing, usability teams, maybe even a user experience librarian, and this is a natural link to make sure that content is actually also usable. And I think that many argue, in fact, I think in the usability community would argue that high usability standards get us all, if not most of the way, to accessibility under the legislation, and we want all of our products and services to be usable. So this is also where so licensing becomes kind of a backstop to the legislation, as do standards. So specifically the Web Content Accessibility Guidelines, WCAG 2.0 standards. So the good news here in terms of law and technology and that lag is that following an advance notice of rulemaking by the Department of Justice, there will be an anticipated refresh of the 508 standards, which will bring them in line with the WCAG 2.0 standards. So it's kind of I guess a victory for staying on the standards track rather than simply trying to meet a compliance. Seeing this as a usability issue and less of simply a compliance issue. And the two, in fact, will become more aligned. Okay. So time maybe to talk about that shared responsibility and institutional roles. This was a report that came out of Senator Harkin's office in September, and it's really predominantly about transforming the American workforce, and talks about the high expectations of the so-called ADA generation, who grew up with accessibility in the built environment as an expectation, and grew up, as I suggested, with K-12 legislation that ensured success in that education. So they arrive on college campuses, and their expectations are high, and they should be. They should expect technology to work. They should expect websites to work. And they should expect that there could potentially even be some coordination in the provision of these services. And I think, again, this is a role for libraries as natural allies. So this was, I think, the very first recommendation in the 2012 ARL report, which was to collaborate within institutions. You are content leaders on your campus. Libraries are technology-rich environments. Many of them are technology incubation places. You have emerging technology. You train on technology. This is a natural partnering role, I think. We talked about the potential for accessibility, bringing accessibility and usability closer together. Some of you may be involved in choosing courseware and licensing courseware and developing it. I think that's an opportunity. And I think it's an opportunity to advance industry standards like the WCAG 2.0 standards, which I'll have a link to at the end. I think this issue is gaining more attention at all levels in higher education, and it is a good opportunity for engagement at all levels with faculty, with students, and on up. So some of the institutional actors are more obvious than others, right? There are offices of disability services, student services offices who provide services. And in the past, when libraries were primarily had print content, inherently inaccessible, had to be reformatted in some way. This was the office that helped students get to, reformat materials, and they helped make great strides with publishers in getting electronic born digital copies in order to, save on reformatting. But they too are overwhelmed by a larger population than they've ever before served, and are natural, I think, partners to libraries. And the opening steps can be pretty easy, right? Establishing liaisons to that office, working, figuring out if there's a team on campus that's dealing with this and being part of that team. Many universities are passing web accessibility policies, and libraries certainly have large web services and web footprints on campus and should be a part of those conversations. And obviously, certainly legal, who's watching out for compliance. But there are many others, and I think we can think creatively about those partners as well. Faculty development centers, diversity and inclusion, because I think this is an equity and inclusion issue, to work with. At a recent NACUA meeting, the College and University Attorneys meeting in June, Scott Lissner, the president of the Association of Higher Education and Disability, argued that creating accessible course content is faculty's responsibility. And I think, the reason I know that is because it was like on the front page of Inside Higher Ed. It was sort of a big claim, and an interesting one. But I think this is a partnering opportunity. I think this is an opportunity to get involved in service provision. I think MOOCs, as we're going to talk about, I think present a huge opportunity here. So if it's not obvious yet, the reason this is data I'm sure everyone in this room also is quite familiar with, and this is essentially showing from, oh, look at that, look how that came out, 1990. Okay, I'll fix the chart, but when I give my slides up, but basically it shows 1992 to 2011, and it shows the percent of our materials budget, and this is ARL data, that is electronic. So right when the libraries mostly bought in print, it was an inherently inaccessible situation. A book had to be, and the community of print disabled readers understood that. As more content, more than 60%, sometimes as much as 80% of content is acquired digitally, there is no reason to assume or accept that digital content should be inaccessible. It's inherently accessible. It's zeros and ones. It has to be rendered in some way. It has to be delivered to something. It can be, that can be refreshable braille, that can be audio, that can be text. But I think one of the most important pieces of our report in the 2012 report, the findings was that most of the user-facing adaptive technology tools require electronic text to be properly encoded in order for that tool to work. So it's not that, so while digital information should be inherently accessible, it has to actually be encoded and built that way. And it is much easier and much more cost-effective to build it to be accessible, to build that, curb cut before the concrete is poured in the digital area than it is to reformat it after the fact or to fix it. And so this is where I would push and hope that for participation on the provider side that we can talk about development and testing and building accessibility into design. But it is this basic requirement that electronic text has to be encoded in this way that is the greatest barrier to making library collections and library-mediated digital resources accessible, and why it's so important to push for this. Okay, so licensing, the importance of licensing. Part of the appeal today too is to break what we know is this kind of vicious circle. Nobody who buys content, who provides technology to a campus wants to buy inaccessible. Nobody seeks out inaccessible content. Of course not. But people do say there wasn't an option, and this is for what I wanted to do. And providers have claimed that sometimes the reason that their products aren't accessible is that there wasn't demand. But again, there's a disconnect. Providers aren't liable for the legislation that we talked about earlier. Your institution is. So we have to have this conversation. and break this cycle. So the recommendation is that accessibility should be, again, non-negotiable, a deal breaker, a central decision factor in choosing and licensing and procuring electronic information products and services. Okay? And here again, I will stress great work being done. Nobody has to go this alone, and nobody has to start making this plan from scratch. There are great work out there. And so a shout out to the California State University. Anyone here from Cal State? Cal State? The Accessible Technology Initiative. And California also has accessibility standards, so you'll see that as well on this page. But checklists, steps to procurement, licensing language, great stuff on this website. So some model language. We have kind of blocks of text in our report, and it's on the ARL website. But model language, as you know, is a moving target, and there are universities who are really kind of pushing on this. But so rather than sort of, so I want to kind of break it up into chunks and talk about what that model language might address. Specifying assistive software or devices, exactly the output that you need. Referencing standards when the standards will ensure usability beyond what the legislation might provide for. So specifically the WCAG 2.0 standards. Requiring a VPAT, a voluntary product accessibility template, which is voluntary but can prove to be an excellent communication device in signing a license. So explain how this product meets accessibility standards that we need, right? So here's a conversation tool. Specify usability in addition to kind of compliance or conformance with legislation. So beyond ADA compliant, and you'll make reasonable efforts to do so, into the content must actually be perceivable. So stricter standards, this comes from our colleagues in the Ontario Council of University Libraries, OCUL, where they have pushed for higher standards, higher than 2.0, and more specific standards within those guidelines, if appropriate. So the point is to negotiate for favorable terms. The point is here too is to both push on and ask for content to be accessible, but then also to negotiate favorable terms to adapt that content if it's not. And this goes back to kind of copyright and pushing on fair use. Aggressively assert a fair use right in support of accessible services. We have one federal district court judge saying it's your primary mission, but service to our patrons is our primary mission. And if the content does not meet, is not in fact usable, you need to aggressively push on that right to provide it. Language and licenses about remediation if the products and services are not in fact accessible. And again, so here's language around that fair use right. Shall have the right to modify or copy. Okay. But I want to close here by asking the question, can we aim higher still? I recently saw Dan Goldstein speak. He's an attorney at Brown, Levy, and Goldstein, which represents the National Federation of the Blind. I recently saw him speak to an audience of librarians and IT leaders at Cornell. And he nearly opened his talk talking about web accessibility by asking this crowd why more universities don't ask their vendors to indemnify them against third-party lawsuits for accessible content, for ADA violations from the use of their products. The providers, as we know, are not going to get sued. Your institutions are. And this just struck me as a remarkably sensible and interesting question, and one I thought this audience would engage. By the same token, what language can you push for that makes it clear, that makes that imperative? How do we get to the imperative part of the title of my presentation? What if it's not? Is it grounds for cancellation? Is it a breach? Are you entitled to reimbursement? I think these are real questions. So this is the conclusion. I hope that we can discuss this further. I'd like to hear from everybody, get ideas about making digital accessibility a matter of equity and inclusion and an imperative. I want to leave you with a short list of resources, and there are more, and I hope that those of you who represent institutions doing work on this or have other recommendations that you want to put forward will say them, and I'd be happy to collect them. The last one, Cornell, is a university currently in the midst of adopting a university-wide web accessibility policy, but it's kind of in flux, and so I don't think that policy has been fully embraced or fully passed. So we'll add that link when it comes, but these are some of the institutions I mentioned and have great both language, procurement practices. Again, nobody's starting from scratch here. So now it's my time to say thank you and conclude my remarks and ask for your questions. Oh, well, or, right, applause line. But questions, please. I hope there are questions or comments.
Well, I don't have a question, but I do have a comment. One of my sons was a student at Virginia Tech many years ago, well, several years ago, and was involved in the Blind Drivers Challenge, which is a senior design group. And they were designing a car for the blind to drive. And the National Federation of the Blind pumped a lot of research money into that. And they have high expectations that their people will do such things as drive one day. So that, I mean, that's parallel with what you're talking about. The blind, I'm only speaking to the blind, not the deaf or other impairments, but they have a high expectation for their students and their children to go to college and to master a lot of these things that we take for granted. So I appreciate your work in that area.
Thank you. Thank you for saying that. That's great. Kevin.
I also just mostly have a comment. I'm fascinated by the issue of whether or not we should be demanding indemnification.
I thought you might be.
Well, I think it's a great idea. It makes perfectly good sense. And in fact, given the national imperative, the legal imperative to comply with the ADA and with the other federal laws, I question whether the indemnification clauses that we do sign, which generally say that we'll protect the vendor, would even be valid. My first step in a lawsuit would be to assert that those clauses are invalid for public policy reasons. But the other thing that leads me to is the connection between that and fair use. One of the things I learned, and it was hard for me as a librarian to think this way, was to think about what lawsuit would I rather defend? If you're going to get sued, we all want to not get sued, but it's really important to think about what lawsuit would you rather defend. And I would rather defend the copyright infringement or breach of contract lawsuit that might arise than I would like to defend the lawsuit brought by a student who can't get access to fundamental materials that are necessary for their education. I'm in a much stronger position. So I absolutely agree with you. Assert fair use if you have to. Disregard your contracts, but do what's right. And then, you'll at least be defending the right lawsuit.
I think that's great.
Defend the fair use question and the accessibility question? Is it better remedy? Is it better?
We should claim it.
Yeah, I think and it's because, we have fair use precedent, we have a lot of case law, and we have enough ambiguity in the fair use statute that I think it's going to be a much easier defense than to say, oh no, we don't really think we were obligated to accommodate your disability, because the law is just really against us there. So I think it's a matter of who's your plaintiff and which law is more likely to be friendly to you.
I do want to ask, and I am coming from the vendor perspective more, are there a lot of issues where universities want to make copies for accessibility purposes, where the vendors are actually just saying no to reasonable requests?
I don't know. But would you, I'll put the question back to you, would you be averse to signing a license that protected that right?
We do it all the time. The issue isn't, the issue from my perspective as a vendor is not working with libraries who want to make the materials accessible to those audiences. It's when you turn it around and say, I have to take my microfilm of early English books online and make them machine readable, because that's a 15-year-long project, right? So it's
right, and
I'm curious of whether we set a straw man and say that we should have that when if it's a problem, shame on us.
Well, I'll give you an example,
Okay.
because I recently met with our disability services folks, and they came to me to ask the question, can we digitize materials, where the vendor has said, yes, we'll provide an accessible copy, But as you said, it's taken weeks, and we're into the semester.
Right.
And the students still can't do their work because it's taking too long. So can we do that digitization now? The vendors already agreed, it's just a delay in those situations. I mean, but they came to me with that question. So
Fair
it is-
question. I mean,
Yeah.
That's the thing, you should say yes.
Well, and I did, you know.
Okay.
But I mean, at least
Yeah.
that is coming up.
All right, so in the interest of balance, let me tell a different kind of story, which is, anyone here from EBSCO? Okay, so last year, as we were, it's like right after we had written the report, I guess EBSCO, the sort of suite of A&I, database services, there was an upgrade to the interface, and it broke accessibility, right? It was suddenly students using screen readers could not do their work, and it was like Thanksgiving, right? So we heard about this because, the National Federation of the Blind heard about this. They contacted us because we had just worked together on this. We had just, they had reviewed the report. And we got in touch with EBSCO, and they said, tell us what students are affected by this. They collected names, they contacted students, they worked through, they resolved every contact. We didn't hear about it again. That was it. So this is, that was good practice, right? That was it was a swift remedy but but this is how fragile this system is, right? This is, when we talk about digital content, we have the content itself needing to be encoded properly, the platform that content sits on, and the device that it's read, okay? And you have proxy servers, and you have web content. There are so many things that have to work together in order for a student to get materials on time and to save. So we're talking about safeguards, I think, for that. Anne?
So I always worry about licensed language versus actual practice. We put things in our licenses and have been doing that for years and years that often, if called to the test, would fail. I mean, some of the classic ones are still perpetual access, where we all sign these things, but if push came to shove, we might not always have that thing that both parties agreed to. The transfer language as well. And ADA, I think, is increasingly showing up in contracts. And I'm wondering if we have a number of producers here, vendors, you'll sign this, but if it actually comes to the test, can you deliver on that? Is it you who delivers? Is it you who makes arrangements with third-party providers that are your conduits to ADA? How does that work behind the scenes, and does it really work?
You're asking me?
No,
Yeah.
the general question is, we can sign things out the wazoo, but unless there's something underlying that, it ain't gonna happen.
Well, again, I guess I would ask the indemnification. I mean, there's a real risk to that falling apart. And so I guess, part of the point of this is to say, I've done license negotiations. I've put in things that say ADA compliance, and okay, we have to get this in here, and this is a matter of compliance. This is not just licensing language. These are, what's behind it is all that you just described with rights and issues there. But on the other side of that are the real students and faculty on campuses trying to access this. So we're talking about, in addition to languages, the other kind of backstops that we need to ensure this. So I should have also put, if anyone is interested in usability and this digital accessibility toolkit, I haven't asked her, but I'm going to go ahead and give you Molly's email address as well, and I should have put this on the slide, but she's molly@arl.org, and she's our National Digital Stewardship Resident Fellow. Building this toolkit, and she is, contact her if this is of interest to you and want to follow her work on that. I'm sure she'll forgive me for that. Yes?
Are there any leaders in terms of vendors that you know of? Because sometimes it seems to me that if platforms are compliant and they're attracting, publishers to come onto their platform, and platforms are compliant, it solves a lot of problems for individuals who might be well-meaning and want to do these things but aren't as aware. So are there, you made me think, is Facebook compliant?
No.
So it seems to me that, the laws are there, but the awareness isn't. And so how do you in a sort of constructive way, make it so that the leaders out there creating these enormous websites advocate for it and they could create such awareness with a button, with anything.
Yep. It's a huge competitive advantage, I would argue. I mean, I would say if I was advising vendors in this area, I think this is a chance I think it's a great chance to be a leader, to promote it, to sign that VPAT, to articulate the ways that to exactly be that, and to be. So one of the stories of the Cal State, one thing that the Cal State Accessible Technology Initiative did was, and this was several years ago, but the Cal State system was licensing Blackboard. And they have 23 campuses, huge campuses that we're going to bring to this contract, and Blackboard was inaccessible. And they said, we can't do it, we can't sign, we need other courseware. And Blackboard in 6 months became accessible, received commendation from the National Federation of the Blind, awards for its accessibility, and now that's a leader, right? I mean, that was a great outcome for everybody. So, yes.
I'm wondering about the use of private resources such as, say, like YouTube videos and things like that in an academic context, especially video, not so much text. Text has enough challenges associated with it, but video in particular, particularly streaming video, particularly content that originates in the private sector is just repurposed, and we don't have obviously license agreements that those are just faculty using that, but what expectations and what legal considerations exist for campus in that regard. And we have people coming to us as a library saying, what can you do for us? Well, it's not content we're licensing, so do we have any obligations or not?
Well,
both on the legal and ethically, you might say we do, but legally.
Sure. Well, so this is like an institutional actor question. I mean, so whose responsibility is it? I mean, as a non-lawyer, but somebody who has been kind of immersed in this, if that content, regardless of where it came from, is part of the course material and part of what the student is accountable for, it really doesn't matter whether there's a license behind it or you piped it in from wherever. The content has to be accessible to every student in that class. So if you're talking about whether libraries should become captioning centers, I can't answer that, right? I mean, that's something that seems to me a potential for libraries to get into to services like that with, under certain circumstances, working with faculty to create good course content, for example. But I mean, I don't think this is really about. Yeah, so I guess I had limitations of legislation. I would call this limitations of licensing, right? Because it's still the content. I mean, it's still what you're responsible for in that classroom, what the institution is responsible for doing. If I go back to that Dear Colleague letter, is the course, this has to be equally accessible to everyone. So that's a good question. And I guess that's you could sort of file that under, are you involved, is there a team, are people coming to the library and asking you this? Do you know people in IT? Do you know people in disability services? Is this a chance to convene a conversation and say, hey, the Faculty Development Center, anybody involved in courseware, you're, somebody in the library who can advise on legal matters. I mean, I just think this is a great opportunity to have a collaborative discussion. It's not an obvious answer in that way.
Coming from most of my career on the publisher side, something that I find most helpful is from the sales side, the people that typically reach out with the institutions, they're less versed in this part of the conversation. So one of the things that's helpful is to make sure that you're on the same page when the conversation starts. It could be as simple as one of the things we're going to talk about today will be ADA compliance or something like that, so that they come into the meeting prepared, so that the conversation is started and you don't start with spinning wheels. Because as the publisher gets larger, and I'm more accustomed to the larger publisher side of this, you're typically a step or two away from the technical development side. So it's good to make sure that your representative is fluent in the language that you need them to be in.
It's a great suggestion.
I think there's also a problem with educating providers of information on a global basis, because we do a lot of business with individuals and publishers from a variety of countries, and they may not have such laws, but if we're buying the content, of course, we have to comply. And probably an indemnification clause, I'm thinking, isn't going to do a heck of a lot.
What about a reformatting? I mean, what about fair use?
Yeah.
I mean, and this is, so the global, I mean, this is, again, you know, we're getting out, this is where I wish I had Prue Adler with me to talk about the WIPO, but maybe, I don't know if Kevin wants to say a few words here, but no, he doesn't. But this is a global issue, and I mean, so I guess that's where, I think you're right about indemnification. I don't think that's going to be a practical outcome.
My limited understanding of the international treaties is that in the United States, we're entitled to rely on U.S. law, which includes fair use.
Okay.
And again, I come back to, if it's a matter of making the work accessible to a student, I would do it first
Yep.
and figure out later
Yep.
how we have to.
Good.
Yeah, I just wonder if you could speak for a second about the assistive technology, sort of the other side of the equation. You know, what's the development and movement in there? What expectations do we have that, you know, they'll sort of meet the student in the middle?
Right. So, I mean, what I said before was that I mean, this also, everything is a moving target, right? So the technologies are a moving target, right? So what worked with the previous version of JAWS suddenly doesn't work with this one, right? So one of the pieces of advice that when we were talking to folks in IT at Penn State, one of the key pieces of advice was design for standards, not for a particular technology, like not for a particular device or version or outcome, right? Like if there's a conflict between those two, if you have a conflict between whether this particular device can render something versus, you know, go with the standard. Okay, so I thought that was, I mean, that makes good sense to me, sort of logically. But I think that, you know, this is where I think well, this is a standards issue. This is where I think the WebAIM and the WCAG and usability in general will advise on properly encoding text so that it can be rendered by a device. Now, whether there's a particular device that fails, again, I think modifications may have to be made. But I think standards, usability standards and accessibility standards get you there where you need to be with devices. It's not a great answer. But it's changing. I mean, it's a changing environment.
Would that imply that you would?
If I was working in a library, I would answer that question by working with disability services and with IT, right? I would say, I would consider that to be a campus issue and a campus conversation and say, you know, what are the practices here? What are we, you know, what are our users need? And have that conversation broadly. So I think it's a great question, but I would have it as broadly, as inclusively as I could to answer that.
Thank you very much to everyone. And Judy, I think we're just in time to have our little 5-minute break.
Great.
And try to be back as close to 10 as possible.
Okay.
Thank you.
Thank you.